Welcome everyone to the monthly breakfast that we have been holding in New York since 9/11. This monthly breakfast is co-hosted by the Association for Conflict Resolution of Greater New York and the CUNY Dispute Resolution Center at John Jay College of Criminal Justice. I'm Maria Volpe. I'm a professor at John Jay, where I also run the dispute resolution program. We used to meet in person for those of you who are joining us for the first time until March, and those of you who were at that March breakfast probably vividly recall how we began to pivot into this new environment that we're in. We were asking everyone to be creative in how we were meeting and greeting each other in that room, to touch elbows and tap toes and perhaps bow. We were trying to find creative ways to maintain some distance and not shaking hands. And to think that here we are now 9 months later, this is our 9th virtual breakfast. And I'm delighted that some of our presenters who have presented at many of our previous breakfasts are here with us. And this virtual environment does give us an opportunity to join with our colleagues around the world who might not otherwise be able to join us. These virtual breakfasts are also posted on the ACR-GNY website, www.acr-gny.org, and we'll soon post them on the CUNY Dispute Resolution website as well. We've been through a lot in these last 9 months. It was the pandemic that created this new environment for us, but we've also had calls for racial justice. We've had an economic crisis, and we've had a major national election. So we are in the middle of a lot of transition. These breakfasts continue. As far as we know, we are going to be virtual now for at least another semester, since the City University of New York has announced that we are going to be operating remotely in the spring as well. So there will be no gatherings for the foreseeable future. These breakfasts would not be possible every month if it wasn't for our wonderful team made up of Julie Denny, Chuck Newman, Matthew Latimer, and Nikki Borofsky. It takes a village every month for us to find speakers and communicate with each other around all the glitches that we might or might not experience. But thank you so much to our co-conveners. And we are so fortunate in this virtual environment to have colleagues from beyond our New York City borders, and we don't have to worry about having travel arrangements interfere with or have to be made to join us. So this morning we have John Lande, who I've known for seems like years now, right? Decades. And John is a pillar of the dispute resolution community, particularly amongst law professors. He's a thought leader. And a real fun fact about John is that he takes pictures. He's sort of the unofficial photographer of all of the events that have gone on now for decades. He has an amazing collection. And if he was in New York now, our breakfast would be part of that collection. Maybe you could take pictures of the screen here, John, and start, finding a new way to collect pictures for your collection. But with that, I'm going to turn this over to Julie to more formally introduce our speaker this morning. Thank you so much, John, for joining us here in New York.
My pleasure.
Well, Maria set the tone. We're really delighted that we have John here today as a true authority. He is the Isidore Loeb Professor Emeritus at the University of Missouri School of Law, and he's the former director of the LLM program in dispute resolution there. He's received a bunch of awards for his work. He earned his JD from Hastings College of Law and PhD in sociology from the University of Wisconsin-Madison. John, you've been all over the place. He began practicing law and mediation in California back in 1980, and he directed a child protection mediation clinic in the 90s. The ABA has published a number of his books: Lawyering with Planned Early Negotiation, How You Can Get Good Results for Clients and Make Money, and Litigation Interest and Risk Assessment, Help Your Clients Make Good Litigation Decisions, which he co-authored with Michaela Keat and Heather Heaven. And he has a website, which I'm sure we'll post, but it is www.law.missouri.edu/Lande. Even though we're virtual these days, we still are mediating. We still have to help disputing parties make decisions about what really is important in their process. And so we're delighted, John, that you're here to help share your knowledge about that subject. Take it away. Oh, I wanted, excuse me, about the chat option on your screen. If you have a question for John during his presentation, post it in the chat session. And if you would personally like to speak your question, start your question in the chat session with the word speak. Otherwise, Nikki will be moderating the questions and she'll say, Julie Denny from Princeton has a question about blah, blah, blah. But if you want personally to speak, put speak at the head of your question. That's it. Now take it away, John.
All right. Well, thank you, Maria and Julie and all the co-conveners, and thank you all for spending some time together this morning with me. I'm excited, as Maria said, I've been thinking about things for quite a while. I think we've known each other probably at least for 20 years, if not more. I'm going to start sharing my screen and walk through some things here with you. And then at the end, we will have a chance to talk. So, so here's the plan for the conversation. I'm going to present the main premises and right now, which are that conceptualizing how parties make decisions is really important to figure out how to help them. So it's the conceptualization, and having clear, concrete concepts are more helpful than vague models. And I'll talk more about that, obviously. And what I'm going to do is I'm going to describe 3 cases to provide the basis for the conversation. These 3 cases come from a study that I did where I interviewed lawyers about cases that they settled. And of course, you all have a lot of experience, and I'm happy to have you refer to your own experience as we go along. I'm going to consider this like a very big focus group. One of the things is was described to have a PhD in sociology. I've done a number of research projects, focus groups. Typically you have 5 to 10 people. So we're going to have a few people more than that here, but I'm going to be looking to get your input, and I'm going to ask you to focus particularly on the concepts, not the specific techniques, as I will describe. And I'm a blogger. I blog on the Indisputably blog. And if you're interested in that, which I recommend, it's just indisputably.org, and you can subscribe to that. And I'm going to summarize the discussion here in a post, probably in a week or 2, something like that, and invite you to take a look at that. And as I say, subscribe. It's oriented particularly to, well, the bloggers are law professors who focus on ADR, but we have a lot of people who aren't lawyers, aren't professors, but who are interested. So I invite you to check it out. As was described, I invite you to respond orally by chat or email for the purpose of this focus group. And I'm not going to be following the chat or the email right now, but if you want to send some email comments to me afterwards, or have a conversation by email or Zoom, I would love that. So I want to start by telling you where I'm coming from to give you a sense of where these ideas come from. And basically the plan for this session is for me to have you understand kind of what the world looks like through my eyes. And then I'm going to be interested to hear what it looks like from your eyes and sort of how our eyes compare with each other. So I graduated from law school in 1980 and didn't like practicing law. It's a little adversarial for my tastes. And I was very fortunate to find out about some mediation trainings, and I took several starting in 1982. And I practiced law and mediation through 1986 in the San Francisco Bay Area. And I then had was a doctoral student in sociology, focusing on sociology of law and dispute resolution, did a number of studies about dispute resolution while I was there, and I've been a faculty member since then. I've written articles, particularly about mediation, through 2008. That was a lot of my focus. I was part of the ABA section of dispute resolution, had a task force on improving the quality of mediation, and we did some focus groups and a study and produced a report, and I was very involved in that. Starting in the early 2000s, I studied collaborative and cooperative law. Some of you may know Julie McFarland. She was studying collaborative law. She came and visited my school and said, "Hey, John, why don't you study collaborative law?" And so I did and wrote a series of articles about that. I bet many of you are familiar with it, but basically collaborative law, for any of you who aren't familiar with it, is a prior parties hire lawyers who commit to negotiate only, that they will not litigate, they won't threaten to litigate, and they have a written agreement at the outset, and the idea is that, and with a disqualification agreement, so that if one side or the other goes to litigation, then the lawyers are legally bound to withdraw. They are not permitted to represent the clients in litigation. And so I was interested in that, the idea that lawyers were going to be doing it. The impetus for collaborative law was to focus on interest-based negotiations. The folks, the collaborative lawyers, really didn't like the adversarial approach to dispute resolution. And so I was very intrigued by that, particularly the idea of starting from the outset with negotiation, as opposed to the way it often happens in the legal process, where people litigate first and then negotiate well into the process, and that has obviously some negative consequences. And I also focused on cooperative law, which is similar, although it doesn't have a disqualification agreement. And then I also wrote about the vanishing trial, which some of you may be familiar with. That's in some ways a relic. People don't seem to talk about that very much. In the early 2000s, Mark Galanter, a professor and actually former faculty member of mine, wrote this vanishing trial study, which got a lot of buzz. And the idea was that trials all of a sudden were disappearing, and that this was a problem, which of course seemed kind of odd from the ADR. And not only was it a problem, but it was ADR's fault. It was our fault that all these trials were disappearing, which of course seemed kind of odd, because a lot of people thought that having trials was a problem. Some of you may remember that back in 1991, there was the Biden bill, when Joe Biden was the chair of the Senate Judiciary Committee, and they produced the law requiring every federal court to try and reduce the cost and expense of trial and reduce trials. So I was focusing on trials, and it prompted me to think about when we would want to have trials or not, and what the value of trials in courts were. And what this led me to do is to focus on dispute systems, including lawyering and courts since then. As was described, I've written 2 books, one, this Lawyering with Planned Early Negotiation, and then Litigation, Interest and Risk Assessment, which just came out earlier this year, which I co-authored with 2 wonderful Canadian colleagues, Heather Haven and Michaela Keat. So let me talk about what we do and who we are. And this grows out of the evolution of my thinking. And that was the reason why I walked through the things that I've done to give you a sense of it. And so here's the headline, which is that our community, I believe, this is how I think of it, helps people make decisions about processes, procedures, and issues in managing conflict. And I think of who we are to not only include private neutrals and administrators and court and researchers, but also including lawyer advocates and judges who themselves are also interested in processes, procedures, and issues in managing conflict. This is a challenging thought, and I wrote about it in this blog post. And what prompted me to write it was a colleague in my dispute resolution center at my law school who teaches trial practice and pretrial practice. And he said, well, is that dispute resolution? And at the same time, I'd also read about a court that was developing an expedited trial process. And so is that a dispute resolution process? And so I wrote this blog post, what is ADR about? And it prompted me to think about including lawyer advocates and judges as part of our community. I would also note that you can see that this is highlighted. It's a link. You will have an opportunity to get this PowerPoint, and you can read this, follow this link and others as we go through that are in this PowerPoint, which will be distributed. And I'll also post it on my blog post when I write up this presentation. So what are we concerned about? We being our community, which includes a lot of things. We're concerned when people have lack of access to procedural options and legal services. And if you think about, when the modern ADR movement started, a lot of people think of it as going back to the Pound Conference in 1976. But if you think about it in the mid 20th century, basically there really weren't very many options. You had court and maybe friends, but not the whole panoply of services that people now have. We're concerned when lawyers are paternalistic and undermine clients' decision-making. We're concerned when parties are stuck in ritualized adversarial negotiation. Obviously, the impetus for getting to yes and the interest-based or integrative negotiation is wanted to have an alternative so that people don't have to have this counteroffer process that can be very hostile and negative. We're concerned when parties are stuck in ritualized mediation with limited procedural and substantive options. And so God knows the mediation movement has an incredible range of different approaches, and we want to have people, the practitioners as well as the parties, have a variety of procedures and options. We're concerned that when parties must mediate in inappropriate situations or poorly designed processes. Obviously, for example, when there's domestic violence or intimate partner violence, that's been a concern among other situations where people may be forced to mediate where people feel that that's not appropriate. We're concerned when weaker parties are required to arbitrate with more powerful parties. We're concerned when parties engage in unnecessary, wasteful, and harmful litigation. I would just note about this that you can see that I've included these qualifiers: unnecessary, wasteful, and harmful. And certainly litigation can be that, although I also suggest that litigation isn't necessarily unnecessary, wasteful, and harmful. And in fact, it's really essential in our system where there are people who are unreasonable, who are harming others, where facts matter, where evidence matters, and we need a process to determine the facts and to make sure that justice is done. So litigation is an important part of our system, although it has obvious dysfunctions, as do all dispute resolution options, including mediation, arbitration, bilateral negotiation, and on. So what have we done in our movement? We have developed public education about dispute resolution options. We've encouraged and developed focusing on problem solving and dispute prevention so that people don't get into disputes or manage conflict constructively ahead of time. We have encouraged unbundled legal services. Many of you are probably familiar with this concept, where the idea is that parties and lawyers can negotiate for specific legal services that they want lawyers to do, but not necessarily have lawyers control the whole case. So it's a kind of case-by-case sort of a la carte legal services. We've expanded the dispute resolution toolbox. A lot of people have used that concept of the toolbox. I've got a link here to a handout that I developed for my course with my way of thinking about the toolbox of a zillion different kinds of ways to handle disputes, not just what Deb Eisenberg refers to as the trifecta of negotiation, mediation, and arbitration. We've got, parenting coordination, MED-ARB. We've got summary jury trials. We've got, mass dispute resolution processes. So we've developed an incredible range of processes. We increased access to dispute resolution processes, for example, in small claims or in lots of different contexts. We have triage systems to make choices of procedural options, which is really important. Again, you can think about, the multi-door courthouse was in some ways the institutionalization of that, the idea that you'd have the court help parties figure out which process would be most appropriate for them. Individual practitioners often provide essentially triage services when clients come to them or would-be clients come to them to say, is this process that you're asking me to provide the appropriate one, or maybe you should be using some different one. We've been providing technological assistance in online dispute resolution, which of course has become much more significant since the pandemic. We've developed early dispute resolution options. We've increased the range of professional techniques, and we've developed a whole way of thinking about not just designing systems to deal with an ongoing flow of cases, not just on a one-by-one basis. So if you look at this screen and the one before, the things that we've been interested in, the things that we've done, we being our community generally, obviously not every one of us, but if you think about this ADR community, it makes me very proud to be part of this community and think about the things that we really care about and all the things that we have done to try to help parties deal with really difficult conflicts, and particularly when they turn into disputes. So, as I said, the focus of my talk today and the work that has been interesting me lately has been focusing on concepts and the value of concepts for practitioners. And I suggest that concepts and conceptual frameworks are helpful to have people understand the world. If we don't have, essentially concepts are language that crystallize ideas. And if we don't have good language, then we can't understand each other. We can't communicate with each other very well. It helps to plan, perform, and analyze our actions and to build theories. And my premise is that useful concepts help practitioners, help parties. And some of you may remember the movie Jerry Maguire with that famous scene where Jerry Maguire is talking to his client, the football player, and he says, "Help me help you, help me help you." And that's essentially what practitioners, dispute resolution practitioners do, is to help parties. And the idea of having concepts and all the techniques that we develop is to have ways to help practitioners help parties, even though we're not sports agents helping football players. Unfortunately, our field is, in my view, a Tower of Babel. And one of the things that prompted me to realize this was in teaching students, and I was teaching them about our classic models of negotiation and mediation, and there's nothing like trying to explain to someone who doesn't know something whether you understand it or not. And it was more complicated and more difficult to explain the reality of what these different models were. And I did a study of negotiation that I mentioned earlier, where I asked lawyers about the cases that they settled most recently. And as part of that, I reviewed negotiation text to see how they discussed negotiation models and even the definition of negotiation. And they were all over the place. There was just tremendous confusion about these very basic concepts, even just the definition of negotiation. And I organized a symposium here at the University of Missouri, and that provides more detail. And again, you can see here the things that are underlined in blue are links, and you can get more information there. And then some of you may be familiar with the task force that the ABA section of dispute resolution did on mediation research, which demonstrated confusion about mediation models. And there are a couple of things there that were significant. One was that the researchers were trying, and when I'm talking about mediation models, they weren't using the terms, but the most common models are, that are talked about are facilitative and evaluative mediation. And the researchers had just a panoply of different terms to describe what mediators were doing that supposedly fit within those models. And they also found that there weren't consistent effects of the particular interventions that they were studying. And so these models were, I found, not very helpful and very confusing. So, and to kind of elaborate, the negotiation models, these, I'm sure almost all of you are very familiar with, one being called distributed, competitive, adversarial, or positional negotiation. The other one being integrative, problem-solving, cooperative, interest-based negotiation. I mean, the fact that there are so many different terms for these models is an indication in and of itself of a problem. And one of the things I also found was that there was a third model that is actually quite common, which isn't described in the text, and I think that probably most people don't even think about them, which I call norm-based or ordinary legal negotiation. And let me just briefly describe what that is. Something that probably a lot of you actually do. It's sort of like you breathe the air and you're not conscious of it. You speak in prose, but you don't think of it that way. Norm-based negotiation is where the norms are the central part of the focus of the negotiation. So for example, in child support, most states in the I think all states in the United States have laws that provide for a presumptive amount of child support based on the income of the parents and the number of children. And what often happens in these cases is that the parties or the lawyers will start with a presumptive amount. Sometimes that's all they will do, and sometimes they'll argue for adjustments, either more or less than the norm. And you can see this in parenting arrangements in family cases, but it's also common in criminal cases and plea bargaining, where there are typical going rates for particular offenses under certain fact patterns, in workers' comp cases, in some personal injury cases, and lots of other cases. So there's this very common pattern which wasn't described in these models. And so what I have argued is that it's better to focus on variables than models. And so here are some of the variables that I found in analyzing the texts about what the components of the negotiation models are. So for example, the adversarial model assumes that the parties have the goal of maximizing their own results. They assume that that the situation is based a zero-sum situation where one person's gain is another's loss. They assume that the other side is a hostile opponent. They use a counteroffer process where they start with extreme positions and make a series of concessions. They focus on the outcome of the best alternative to negotiated agreement. In the legal context, this is typically the expected court outcome, and they use a variety of hard bargaining tactics. Now, the assumption with the model is that all of these things go together. You have a coherent set of all of these things happen in the same way. And you can think about the cooperative model as being the opposite. So instead of the goal of maximizing the negotiators' results, it's to have a joint gain. Instead of zero-sum assumptions, it's a positive sum. Instead of treating the other side as hostile opponents, you treat them as potential collaborators or partners. Instead of using a counteroffer process, there's a kind of brainstorming process of identifying interests and options. Instead of focusing on the outcome of the BATNA, the focus is on what the parties' interests are. And instead of using various hard bargaining tactics, there's a process of sharing information and tactics to promote cooperation. And again, it's assumed that in this integrative, interest-based, principled, whatever you want to call it, model, all those things go together. And what I found in my study was that that happens sometimes, but not all the time. And a lot of times there was a kind of mix and match of these various variables, which is part of what prompted me to suggest focusing on the individual variables instead of the models themselves. So for example, one of the things that I found was that in the typical, what I call the counteroffer process, which people might think of as the adversarial model, where parties do have a goal of maximizing their results, they didn't treat each other as hostile opponents. They were often quite friendly and polite and professional. And they would focus on the BATNA outcome, but they wouldn't always. They would sometimes use hard bargaining tactics, but wouldn't always. So part of it is really disaggregating or unbundling the variables in the model. And if you're interested in looking into this, here's the article that I wrote, and here's a link to it, and you can read it for more detail. And there's a comparable situation for the mediation models. The most common are the facilitative and evaluative models. Len Riskin, my former colleague here at Missouri, combined very different variables, and they're considered all together. This mediation quality task force that I was on did a survey of mediators and found that the mediators had different views about which tactics were particularly helpful. So for example, giving a case analysis, including the strengths and weaknesses, 2/3 of them thought that it would be helpful in most cases, but recommending a specific settlement was only 38%, making prediction about likely court results 36%, and applying some pressure to accept a specific solution. Only 30% of the mediators in the survey thought that those would be helpful techniques. So these are very different things, behaviors, and people had different perceptions about their value and usefulness. So here's my proposal in terms of what we should do with our negotiation and mediation models, which is to throw them in the trash. I understand that this is hard. These are models that people have known and loved and taught and learned and shared with others. But for the reasons I've just described, I think that they're problematic and confusing, and prompts me to suggest this other way of thinking about it. And so for me, the way I think about what our field is about and what our goal is about is to help parties make decisions. And certainly, for mediators, this is very clear. Mediators are not here to make decisions. They're here to help parties themselves make decisions. And, people may not think about lawyers in this way, but if you look at the ethical responsibilities for lawyers, that's their job too. Lawyers have a responsibility under the ethical rules, at least in the United States, and I suspect it's true in most other Western countries at least. Lawyers have an obligation to respect that parties are the ones who make decisions about what the goal of the case is and whether to settle or go to trial. And not only that, lawyers have an obligation to provide important, necessary information and candid advice for parties. So this is all a reflection of the fact that even in cases where client parties are represented by lawyers, the lawyers are there not to make decisions, although they sometimes make some specific decisions to implement the parties' goals, but ultimately the parties are the decision makers. And even in arbitration and litigation, where adjudicators make final decisions, parties make lots of decisions along the way, including whether to settle, as well as how to handle the case. So the central premise of my thinking in this talk is that what we do is to help parties make decisions in difficult situations. So what do? We help parties make decisions often when they lack good or any other practical decisions. And there are a couple of ways we do this. On the most basic level, we help them choose a process, which may include negotiation, mediation, arbitration, litigation, trial, or any of the other ones in the toolbox that now exist that are available. So that's sort of a first threshold kind of decision that parties make. Sometimes not consciously, sometimes that isn't even a decision, but it's one that we can and often do help them make. Once they're in a process, we help them design the process by making procedural agreements. Mediators have become increasingly familiar with this phenomenon of making procedural agreements about planning mediations ahead of time. Again, sometimes in terms of information sharing, who's going to attend, logistics, all sorts of decisions about how the process is going to work. And then, of course, the decisions about whatever the dispute is about itself. So we help parties make a variety of types of decisions along these lines. And then this book that I just recently co-authored with my colleague Keith and Heather Haven, Litigation Interest and Risk Assessment, Help Your Clients Make Good Litigation Decisions. Obviously, and the subtitle itself is about helping clients make decisions, provides a three-part structure to develop useful strategies and bottom lines for negotiation and mediation. And the three-part structure includes focusing on these three elements. One is the expected value of the options, also known as the alternatives to a negotiated agreement, the tangible costs of the process of continuing, and the intangible costs and interests. And what we suggest is that it's really helpful for the parties and the lawyers and mediators working with them to analyze each of these separately and to then combine them to help parties develop their strategies in terms of what they want to do in whatever process they're in, as well as bottom lines for negotiation and settlement, or mediation and settlement, what their walkaway point is if they can't reach a suitable agreement. And then if they're using a counteroffer process, having a bottom line is helpful for developing that strategy in terms of initial offer and counteroffers. And so negotiation and mediation can help parties focus on these factors, and dividing those in this way into these three elements can be very helpful to do that very explicitly, both for the practitioners as well as the parties in making their decisions. So based on all of this, I've developed these tables to kind of summarize some of the issues and what practitioners can do. So this table just summarizes the last couple of slides that I did. You can think about the kinds of decisions that parties will make about the process, the type of process, the procedures in the process, and the resolution of issues, and then the factors to consider: the value of the options, tangible costs, and the intangible costs and interest. You can see here in the right column, I've listed some examples of these variables. This is a PowerPoint, not one of my law review articles, so this is not an exhaustive list of the variable, the possible illustrations of the variables, but these are some that will give you some feel for it. And then it may be helpful to think about the kind of cognitions and actions that parties and practitioners have as they're dealing with disputes. So you can think about what their goals are. Is their goal to develop to gain partisan advantage, develop a joint gain for the parties, or a fairness? Are there assumptions that it's a zero-sum situation, a positive-sum situation, or a negative-sum situation where both parties or all parties are going to lose? And the question is, who's going to lose how much, or who's going to lose more? What are the attitudes towards the counterpart? Are they hostile, polite, or friendly? Are the norms that are the basis of decision the law, the party's interests or normal practice? Is the communication process the counteroffer process of starting with extreme positions and making a series of concessions or of interest and options, or focusing on norms? And then those whole series of various tactics which practitioners are aware of. Some of them are in the category of dirty tricks that to try and gain partisan advantage, or sharing information, and a ton of others, which I'm sure you are all familiar with. And then you can think about what practitioners can do to help clients. So one of them, we can listen, we can help parties assess cases, we can assess the options ourselves in a variety of ways, predict outcomes, give advice and apply pressure. And then within each of the variables, there are ways to break them down. So for example, in terms of listening, how much we listen and how well we listen and how much we understand, in terms of whether helping parties assess the case, if we offer help at all and the amount and quality of help, and the same with assessing options, predicting outcomes, and so on. And what you'll see is, and what I argue is that we need to unbundle and unbabble our models and make them clearer. And you may have noticed that in the preceding two slides that they relate to our cherished models. So the goals, assumptions, attitudes towards counterparts, norms, process, and use of power are elements in the adversarial or cooperative negotiation models. So basically, I'm suggesting that instead of saying adversarial or cooperative, focus on the particular goals or assumptions or attitudes, and recognize that they may change over a period of time. Similarly, listening, helping parties make assessments, having practitioners make assessments, predicting outcomes, giving advice, applying pressure are elements on the spectrum of the facilitative evaluative mediation models. So having just walked through these concepts, I want to provide a basis for discussion using some actual cases from the interviews of the study that I described. So they're a divorce case, a union grievance case, a personal injury case. And the purpose of this conversation is to test what concepts will help practitioners help parties. And so what we're about to do is have this focus group, have this discussion. And what I'd like to invite you to do is to say to talk about how helpful are the concepts that I've just presented. How are these concepts problematic? And are there other concepts that would be helpful? So again, this is a focus group kind of thing where I want you to tell me what works with these concepts, what doesn't, what else would be useful to add to them. And I want to encourage you to focus on the concepts that help plan and use techniques, not the techniques in themselves. And the techniques obviously are important. I'm sure that all of you use a variety of techniques and could talk about them. For the purpose of our conversation today, I'd like you to focus on the concepts, the way you think about them, and the way you communicate with parties and others involved in a case, to think about what is helpful in doing that in a constructive way, not in the techniques themselves. I say this, I've been to lots of situations, lots of presentations where people will talk about cases and the techniques that they've used, and will go on at some length about the techniques. And techniques are important. My two books are full of them. The Lawyering with Planned Early Negotiation has a table with 49 techniques for dealing with impasse or problems. Both of them have lots of appendices with questions to ask. Techniques are important, but for now, what I wanted to encourage you to do is to think about the concepts that may be helpful in dealing with it. So here's one case. Here's a divorce case. I've made up names for all of these because I didn't get the names. These were confidential discussions or descriptions from the lawyers who told me about it. So Salam lost his job where he earned $65,000, wasn't working. He was having a hard time getting another job. The best offer, he'd gotten several offers. The best one was only for $38,000, but he didn't accept it. His wife, Wendy, was a stay-at-home mom at the time, and she now works as a house cleaner. Wendy initiated the divorce, but values Salam as a father and didn't want to hurt him. The real problem in this case was the amount of child support. Those of you who are familiar with family cases, there's a process where you can what's called impute income, where someone isn't actually earning income. And the question was, how much income should they use to calculate the child support and what the child support amount would be? Now, while they had a lot of intense conflict about the child support, they had no problem working out the parenting arrangements. This was an example of that norm-based negotiation that I was talking about. There are very common parenting arrangements, and they worked that out fairly easily. They had to sell their house and do a variety of things in order to get it ready to sell, and they were able to work out those arrangements quite cooperatively. That sounded more like what we would typically think of as more of an interest-based negotiation. And the lawyers previously had worked together cooperatively. Now, again, I'm not here telling you what the outcome was, aside from the fact that they settled. But here's a way to just think about a concrete case, to think about what concepts would be useful in analyzing and helping parties. So that's the divorce case. Here's a union grievance case. Chen was a trucker, and he was fired after losing a commercial driver's license due to an arrest. He had demanded $30,000 in back pay and reinstatement. The company offered reinstatement, but no back pay. I was kind of surprised that they offered reinstatement since he had lost his driver's license, but that's what the lawyer told me. It was apparently a very tense, hostile set of negotiations. The lawyers fought over everything. Chen was in a desperate financial situation, so he really needed the money. The union, which was representing him, was getting a lot of pressure from its members to really stand up for Chen. The company was very concerned about its relationship with the union because they were anticipating an upcoming collective bargaining negotiation, and they didn't want this settlement to set a precedent. And the parties exchanged offers, but didn't explicitly discuss their interests. Clearly, the lawyer who I interviewed for this and understood, were described what he understood to be these interests, and I assume that the company and their lawyer probably did, as well as probably Chen as well, but they didn't explicitly discuss it. So that's the union grievance case. Here's a personal injury case. Sonia was in a car accident with Levon, and Levon died. Sonia was seriously injured, and she immediately filed suit. Her lawyer is concerned about possible distribution of Levon's assets if he didn't file suit immediately. Sonia was a nurse, and she had to change careers because she had PTSD. Both sides completed extensive discovery. The lawyers hadn't previously worked together, but their interactions were professional. So these are three cases that may help you talk concretely. You may also talk about cases that you have had experience and illustrate concepts that you find helpful. So with that, I just want to open the discussion about what concepts would help practitioners, help parties. And then I also want to just note here, the last slide is if you're interested in this book, here's a picture of the cover, a link to a description of it, and a link where you can order it. And if you order by December 31st, it's a great present for Christmas. Everyone would want this book. Who wouldn't want a book on litigation, interest, and risk assessment? So there it is. I'm going to stop here and see who would like to jump in and talk about what concepts would help practitioners, help parties. And with that, I'm actually going to stop the share so that people can see each other better. So here we go.
So welcome, everybody. I just want to encourage you to raise your hand virtually. If you do it physically, I'll have to be scrolling through to see you. If you have a comment or question that you'd like to add, and as we kind of give you a chance to prepare yourselves, I'll just ask a couple of questions that came through while you were giving your presentation, Professor, if that's okay.
Please.
We had Marty from New York City who asked about the best way to advertise an arbitration or mediation practice that is going to be seen by attorneys and agencies. Some free advice.
Right. I'm not sure I'm the best person to answer that. You know, I'm a pointy-headed academic who just sits in my ivory tower all day. You know, I was in private practice in the early 80s. You know, I don't look as old as I am. I'm, you know, really, you know, centuries old. And it was a little different back then in terms of, gosh, I'm not sure how to answer that. I mean, there are a lot of things, and I wish I could give you some good advice. That, you know, the general advice people give is personal contacts, networking, writing, speaking, going, you know, being part of professional associations like ACR and others. Probably the best I can do. So let me stop there. What's the next one, Nikki?
The next one I'd like to jump from is from Kira, who was asking about how some of your frameworks are different from the work of an ombuds who helps parties map out how they'd like to handle their conflict.
Well, thank you. Kira, was it?
Yes.
For a great question. And that's a wonderful illustration of, you know, ombuds is one of, you know, those processes in the toolbox of different dispute resolution processes. And what I would suggest is that these elements can be used for analyzing, you know, so you could analyze the parties, you know, what their goals are and what their assumptions are. So you could use the same set of concepts in an ombuds process, I would think, and the kinds of decisions about what procedures should be used, how you would design the procedures, what the issues are. My sense would be that, and this is a wonderful illustration of the point, that it can be used in, you know, a whole variety of different processes, not just negotiation or mediation. And one other thing I should mention generally is, as you know, I'm a lawyer, a law professor. A lot of what I have focused on has been disputes in the legal context. My assumption is that these concepts could be used in other contexts that aren't particularly legal, such as ombuds, although I don't have as much experience here, and I welcome your feedback and whether you think, for example, in an ombuds or other process, these concepts would be helpful or not.
Great. I think Caroline has her hand raised and herself unmuted and has the next question.
Hi,
Caroline?
Yes, I'm Carolyn Lukaszewski from New York City. I have a question. You know, a couple of days ago, I participated in a workshop with a professional mediator who was an attorney who deals with commercial cases. And I was so fascinated that she said that she does not take on any cases in which she doesn't feel absolutely convinced that the disputants are committed to the mediation. The reason that surprised me is I just can imagine so many situations where, and I'm thinking here about Zartman's concept of the herding stalemate and the way out, which I adore. But I have to say that I think that sometimes people are so emotionally glued to a concept or an idea or a situation that they find it very, very hard to let go of it. And they, even in a distorted way, might think that there's some chance of returning to the pre-conflict situation. Therefore, I think a mediator could be extremely helpful in getting that person beyond the herding stalemate to realize there will not be a possibility of returning to this pre-conflict situation and kind of move them along to really sign on to the mediation process. And I'm thinking also that in cases of trials, I mean, this is one reason judges, I think, refer cases to mediation, because there's the hope that that mediator somehow will convince them to come on board. And I just wonder what you think of that. I mean, this person seems so definitive about this, not taking on any clients unless they were absolutely committed to mediate.
Sure. Well, I guess in terms of the particular mediator's judgment, it's a reflection of one mediator's view. Obviously, lots of mediators have different perspectives. The way I would apply the concepts that I've just described would be to say the mediator was thinking about the goals and assumptions of the parties, and the mediator presumably was thinking that I gather this is a woman, or
yes, it's a woman.
She was only interested if the goals were to reach an agreement, and the assumption was that they were operating on an assumption that that an agreement was possible, and so what else? And that and presumably that the attitude towards the counterpart would be friendly enough so that that it would be possible to do it. So I guess to me there would be that's how I would frame that, and in terms of whether that's a good way to do it or not. Obviously, each practitioner would be making his or her own decision about what to do, and the idea would be that concepts like this would be helpful in deciding what you want to do or not. Does that make sense?
Yes, it does. I mean, I think the key there is it could be helpful to people in kind of coming around and seeing the optimism that might be present there.
Yeah, and to have the practitioner decide for him or herself what they want to do or not, and how they want to select which cases they're going to take on or not, and how they're going to intervene or not.
Thank you.
Nikki, I got a question that only came to me, so I'm going to just jump in.
Oh,
here.
no.
Will Sparks wants to know from you, John, to what extent you have experienced in your lengthy ADR career the assumption of parties that they will not get true justice until they get their day in court, literally not a conference room, whether mediation or arbitration.
Well, that's a common thing that people feel, that they want this day in court experience. In our litigation interest and risk assessment book, we describe that as one of the parties' intangible interests, that they want to feel heard, that they want to have publicity, that they want to maybe have vindication. And so identifying what their goals are is important. Now, practitioners, mediators, and lawyers often are somewhat cynical about this, because they find that at the end of the day, people who say that they want their day in court nonetheless find that they end up being willing to settle for something without a day in court. So it's, you know, in terms of what they do is, you know, think about how to help parties make judgments about what's really most important to them, and having this, you know, inventory of what their interests are is really very helpful. One of the things that I feel particularly good about this litigation interest and risk assessment book is that we go into a lot of detail. We have 2 full chapters about what the parties' intangible interests are, which for those of us who are interested in interest-oriented processes is very helpful, and people think about them, but our experience, and particularly based on the research that Mikhail and Heather have done, illustrates that lawyers in particular and mediators often don't focus on these intangible interests very much. They often do it late in the process. They don't value it. And part of what we recommend is that people, practitioners, really work with clients to flesh out what their true interests are. So, I mean, in terms of the client who says, I really want my day in court, to have a series of questions, a conversation with them about what that means to them, why they want that day in court, what they think that will do for them, how this compares with other interests they have in terms of getting a particular outcome in court or a variety of other interests that they may have. One of the things that I learned was how stressful litigation is. I mean, in some ways, this probably is not news to most people here, although, you know, even being in the field for as long as I have, reading the research about how it can create a lot of physical and psychological damage, literal damage from being in court in litigation is very important. So I'm going on at some length about it. So partly, I guess what I would do would be to say, yes, that happens a lot. And what practitioners should do would be to inquire with the parties and to ask them how much they value it. How much is it worth to them to have their day in court? If they could get if they're a plaintiff and they could get $100,000 in settlement, would they take 110? If the other side is offering, if they think they get $100,000 at trial net, would they take 110 instead of getting their day in court? Part of it is helping them put a value on what their interests are. So anyway, I've gone on for a long time. Let's move on to the next one.
Thank you. I wanted to share the next one that comes from Nancy Grundman, who asks, where do you see this discussion in the realm of community mediation, where attorneys are either not part of the process or more outsiders to the process?
Sure. Well, and I guess my hope would be that the same concepts would be relevant. I mean, so for example, looking at analyzing the party's goals, assumptions, attitudes toward the counterpart, relevant norms, communication process, tactics, none of those assume that, lawyers are involved. And in terms of the kinds of activities practitioners can do in a community setting, listening, helping parties assess the case, providing assessments of their own, predicting outcomes, and so on, those can be done in a community context as well and don't involve necessarily lawyers at all or the prospect of going to court. So my assumption would be is that, and my goal in developing this would be to have something that's generic and not limited to a law-oriented process. I guess I would invite people on this call to tell me if you, either during this discussion or afterwards, if you agree with that, or if you think that there are limitations about these concepts that wouldn't be applicable in situations that you deal with.
Great. The next question is from Nick Rigby, who's joining us from London. Nick, are you able to speak your question?
Yes, if that's good, yeah?
Yep.
Okay, so my question, John, is that I think it's really important to try and get the dispute parties to think about this from the other party's perspective. And in particular, one of the things I always look for, and I act as an advisor to parties when they're in a dispute, not a mediator, but I actually set out those things that are at low cost to the party I'm working for, but a high value in perception by the other side. And the cases that the three cases you set out look particularly fruitful from solution by looking for those factors. Is that fair?
Absolutely. And I thank you, Nick, for that. And part of what we do in the Lyra book is to explicitly talk about your suggestion about looking at it from the other side's perspective. And so from the party's perspective or from the practitioner who's working with parties, you can ask them to talk about what they believe the other side's goals are, what they think the other side's assumptions are, what they think the other side's attitudes are. So not only doing the self-analysis, but doing an analysis of the other side's mindset and what their plans are. And that's really critical. I mean, from a, if you're going to represent a party, the approach that you take is going to depend both on your client's interests and perspective, but especially on the other side's perspective. If you want to have a cooperative negotiation, the other side is not interested in cooperating, then that's not going to work well. And you need to be thinking about the other side's perspective in developing a useful strategy. And one could go on from there. So the general point of not only focusing on one's own perspective, but also the other's perspective is helpful. And my hope would be that these concepts would be useful in doing that analysis of the other side as well as one's own.
Yeah, thank you.
Excellent. Our next question is from John T. O'Malley from the Dispute Resolution Center in Hudson Valley. John?
Hi, John.
Hi, John. Thanks for doing this. I really appreciate it. There's three topics that have come up in this discussion that really stretched me a little bit. But one of them in particular is that, the part I do community mediations, which mostly doesn't include attorneys, but every once in a while we have one or sometimes both or whatever. But when I say community mediation, some of them are, pre-Zoom, they were in a courthouse and different courtrooms, in the Hudson Valley in New York, pretty rural area. Sometimes we would be given a case by the judge and said, come back in 15 minutes, and they send you into a broom closet. So it's very difficult to do a real intro and sort of change the parties' mindsets. One of the reasons why I so much prefer doing our mediations at the office before Zoom or now on Zoom is because I really have a chance to try to change the mindset of the parties. I mean, they've been gearing up. They had a conflict. They've been fighting with each other. They've tried to deal with each other in their own way, maybe overwhelm one another. Maybe they lawyered up. Maybe they didn't. Somebody had to file charge. I mean, they're all, they show up to the mediation with a stack of 42 pictures that they want to show you about where the dog crapped on the carpet or, what the car dents or whatever. And so, really making them change their mindset, shift from that is really so important, but it's not as easy as doing it, after the fact, right? So really trying to do that is different than I think what the one woman from New York was saying, how the attorney wouldn't take cases unless she was convinced that the parties were already committed to mediation. And I find that to be a problem because some of the mediations that we do and that we teach in our area, we really try to tell the mediators, don't think about your record. You know what I mean? This isn't about, I'm the best mediator for this judge. This isn't about, I want to make sure I do 8 out of 10 with successful agreements. I mean, any of those agreements are not going to be durable enough. So the other thing it made me think of is whether or not people say, is it worth my time or not? And then the last concept that I'll mention before and I'll be quiet and let you go, is that when I did a Zoom video recently, I figured out this new concept, which people may like, and that is that when I have the mediation in the beginning, I ask the parties to give me their sort of opening summary, whatnot, where they're telling me why they're here. But then once we actually start the mediation, I ask them to pin their video on each other, so that the two parties, when they're looking at the screen, are looking at the screen of the other party only, and I'm just a little minimized thing up in the side. And that really, it's the same as when we set up the room right before a mediation. When I do arbitrations, I have myself sitting in the front and the two parties looking at me. But when I do mediations, I have myself sitting on the side and the two parties looking at one another. So I just wanted to see if you would comment on those three topics.
Okay. I'll work backwards, especially since I can't remember. You're going to need to remind me of the first two. But the Zoom, one of the fascinating things is how Zoom is changing how people interact, and clearly there are similarities, but there are differences, some problems, but also some opportunities. And what you're describing with this pinning process, which I hadn't heard of before, is an example of how people can constructively take advantage of, these video platforms to improve the process. One thing that I've written about is in the context of some significant legal conflicts is doing what we call multi-stage mediations, where instead of having these long marathon mediations that may start in the morning and go late at night, to break it into into numbers of stages over a number of days, which can improve the party's decision making, because people get tired and it degrades their decision making ability, and because people don't need to travel, they can they can get in and out. You can involve the high level decision makers who don't have to be there all the time. So this is one example of how Zoom can help in the decision making. What were the first two questions you had?
What's my record, and is it worth my time?
Right. Well, that's I guess thinking about what the practitioner's goals are, and different practitioners have different goals. Hopefully, I mean, I think I understand why mediators are concerned about their records, particularly in a competitive market, where in the legal context, particularly, which is not the one that you're discussing, mediators may not get hired again if they don't produce agreements. And so there's a lot of pressure on mediators to do that. And even when there isn't, there may be an internal psychological pressure. I know back in the dark ages when I mediated myself in private practice, I was aware of that to some extent, and I tried to resist it. I would think of my job as a mediator as trying to provide the best possible settlement opportunity for the parties, but it was up to them to reach an agreement or not. And I got pretty good at becoming emotionally detached from whether they reached the agreement or not. But that's hard. Our egos are involved, our self-image, and it takes, I think, some conscious work to avoid feeling that way. And I wasn't always successful. So that was two. What was the last one?
I guess just to add to what you just said, I mean, I was thinking about your comments when you said, we're not here for our purpose, right? We're here to help the parties make decisions. And I really take that concept very seriously. And of course, because I'm not a paid mediator, I'm a volunteer, it's a lot easier for me to do that, right? So I can say, some parties are going to have an agreement. Maybe parties aren't understanding one another. So we help them to understand one another. Maybe they're not seeing all the facts from the other side. So we help them see all the facts. In the end, though, it's their choice and it's completely voluntary. And if we get too involved with a lot of the things that you listed on your slides, then it's no longer voluntary. Now it's an agreement between them and me, which isn't really their agreement, right?
Well, depends on whether they are, how much they are choosing to do it. I mean, in some ways, one of the concerns is if, for example, mediators or lawyers are pressuring parties into reaching agreement, and the extent of pressure, and that's a real problem. Obviously, there's a kind of continuum of things and that mediators may do that would put more or less pressure on, but it's a problem if there are certainly coerced agreements, or if there's excessive or inappropriate pressure. Now, how you define excessive or inappropriate, people will differ about, and we could have a conversation about that. Thank you, John. What's the next one?
Thank you. I'm sorry. Go ahead.
Oops. Oh,
Yeah, maybe we go to someone else, John, if that's okay.
Yeah, that's fine. No problem.
We'll pivot to a question from Chris Houston, which actually is in a little bit of contrast to a comment that just appeared from somebody from Oklahoma City who noted that attorneys can often be the greatest tools for mediation with helping to reinforce points. But Chris asks, what insight can you lend us for dealing with mediations in which lawyers are paternalistic and may lose sight of the fact that the parties should be involved in the decision-making process and have to live with the ultimate outcome?
That's a real challenge. And gosh, people have been talking about that for a long time. And I would just say at the outset that there's no guarantee that a mediator can be successful in that. A lot of things that I've heard that mediators have done will be to have separate conversations with the mediators who are creating, from the mediator's perspective, problems where the lawyers are interfering with the party's decision making and are making it more difficult to make the mediation move forward, and try and understand what the lawyers' interests and perspectives, their goals and assumptions are, and what their perception of their clients' goals and assumptions are. One of the things that I have learned in my many years is that lawyers often, or sometimes anyway, have what are called, and I don't like this term, but it's a common one, client control problems, where clients have strong feelings and lawyers are having a hard time managing them. Now, what you're describing may be the opposite, where the lawyers are the ones who are being more controlling, although sometimes that's what it looks like. But if you understand what the relationship is between the lawyer and the client, maybe the lawyer is acting in that way because the client is egging them on. So I guess the technique that I would suggest would be to focus on these concepts in a separate conversation with the lawyer, to ask them about what their goals and assumptions are, what their attitudes are towards the counterpart, and what techniques might be most useful to talk about what the intangible costs and interests are. So basically, using these concepts in a separate conversation with a lawyer to see if you can figure out what the problem is and why you're not making as much progress as you think would be possible.
Thank you.
Thank you, Chris.
Thank you. The next question, I think, is from Onawa from the New York Peace Institute in Brooklyn, who asks, when a case boils down to lawyers' fees and the process is structured accordingly, how can these concepts be helpful? Are some cases just not able to be mediated?
Well, certainly some cases are not able to be mediated, and they shouldn't be. I mean, it would be a problem if 100% of cases that go into mediation reach an agreement. You'd think that that would be an indication of coercion in some cases, and not every case is appropriate to be mediated. Now, in terms of attorney's fees, I know that this often, or sometimes, is an impediment to reaching an agreement, because the attorney's fees that parties have used, have incurred so far, eat up so much of the benefit for the parties that it makes it very difficult to reach some agreement. In terms of using the concepts, this is where thinking about the LIRA elements of, and the tangible costs, which I didn't describe in detail, include lawyers' fees and other litigation expenses like discovery or expert witness fees, and looking at specifically how those affect what the net benefit would be to the parties, what their bottom line would be. Now, again, having that, this provides a conceptual tool for having that conversation. Having that conversation doesn't necessarily mean that you're going to have a successful outcome. You know, the first book that I wrote, Lawyering with Planned Early Negotiation, which grew out of my study of collaborative law, was focused on, I've been really interested in early dispute resolution, because the earlier people can reach agreement, the less they incur legal and other tangible and intangible costs, and so the greater the benefit for the parties. It can be a challenge to do that, and you can't always, I mean, ideally, and what happens often is actually a lot of cases are settled without anyone filing a lawsuit at all. And sometimes people, where they're represented by lawyers, will have a very have a process where they're focusing early on in trying to reach an agreement as efficiently and as quickly as appropriate and possible. And if you do that, then that can reduce the amount of legal fees, and that reduces the kind of barrier that you were asking about.
Great. Caroline, do you have another question? I see your hand is still up. I don't know if that was a residual hand or a new question.
Actually, I do have another question. I was wondering, John, I gather from everything you've said so far that you are quite facilitative and collaborative in your approach. And I was wondering, though, if you ever find yourself, caught between a rock and a hard place where suddenly things take a turn and you find that you have to step in and take a more directive approach. Does that happen very often in your experience? And if so, how do you handle it?
Well, one thing is that I don't mediate. I don't practice. As I say, I'm just a pointy-headed academic who sits in my ivory tower with the sunset in the background. So
what advice would you give then to people who do?
Yeah, and I guess I would say I am interested, I think people should be focusing on all of the elements, these three elements in our LIBRA structure, including and all the techniques that we describe. And so, for example, we describe the kinds of, lawyers assessing or mediators assessing, but particularly lawyers assessing options, predicting outcomes, giving advice, and even sometimes applying pressure can be a helpful and appropriate thing. So I guess to me, it's a question of judging what the needs are, and what techniques would be most appropriate. And, when I say applying pressure, I think about situations where you have parties who are not doing what they should do. So for example, let's say you're representing a father in a family case, and he should be paying child support, but he isn't willing to do that. I think it's appropriate for lawyers to be putting some pressure on the client to say, you need to be paying your child support. You need to be complying with the law. And so I guess it's, to me, a question of analyzing these various factors and figuring out what the most appropriate activities are. And in terms of mediation, again, I don't mediate myself, but and this may be something that some people on this call might disagree with me about, but I think some of these activities, in terms of mediators giving their assessments or predicting outcomes or giving advice, can be appropriate at times, particularly if the parties are represented by lawyers, and particularly if they are asking for it, and particularly if it's given in a certain way in a certain time. So I guess I'm not, I do think that it's really important that lawyers and mediators have a good conversation with the parties about what their intangible interests are, because they tend to be overlooked. That said, that's part of an overall analysis of a case and an overall part of thinking about what the practitioner's strategies may be. And there may be a variety of different interventions that practitioners may use. And one of the things that I learned in this study is that, this is a process that doesn't happen at a single moment in time. It unfolds over a period of time, and different interventions may be appropriate at different moments in a process, which is one reason that I don't like these global models, for example, facilitative and evaluative mediation, mediators may be doing particular elements of things at a particular time, and that may or may not be appropriate. So does that make sense? Does that address your question?
Excellent, thank you.
Okay, other things?
We're drawing close to the turn of the hour. I'm not going to say what time it is since we have so many people joining us from different areas. But there was one kind of resource question from Robin Beckhardt in New York City, and she asked where people can find the list you mentioned of techniques to help parties get past an impasse.
Sure. That is, thank you, Robin. That is in my wonderful book, my other wonderful book, Lawyer with Planned Early Negotiation, which I would hold up here, the cover, but I don't know if you'll be able to see it with my background. But it's, and that one is really oriented to lawyers, although that set of techniques and a lot of things in there could be relevant for mediators as well. And this list of techniques were things that probably most of you are aware of. What I did for that was I read, a lot of different resources about things that people can do to get past impasse or deal with problems, and I just collected them. Some of them were very obvious, like take a break, have a meal, ask people what their interests are, what their expectations are. So these aren't rocket science, although maybe I should tell you they're rocket science and you'll buy the book, but assuming that you want to do rocket science mediation. But there are a variety of them. What's useful about it is just seeing it in a sort of comprehensive way. So let me stop there. Are there other things?
There was one question from, I think, Bern, Switzerland, about whether we still have time to dive into the case examples that you have with 3 minutes remaining. I'm not sure about that.
Oh, let's go for it, briefly at least anyway. And was there a particular question?
I don't think there was a particular question. I think it was just
Well, okay, let me, I'll give you one example. That the divorce case was one that I thought was very useful in illustrating the fact that in a single case, you had 3 different models of negotiation. You had the more adversarial counteroffer process about the child support. You had the norm-based process for dealing with the parenting arrangements, and more of an interest-based process for dealing with the selling the house. And what this illustrates, and it goes back to a point that I think I was discussing with Carolyn, was that if you break these models into these component variables, it's a helpful way of thinking about it. And instead of saying, I mean, if you think about that case, was that integrative? Was that distributive? Was it cooperative? I mean, parts of it were very adversarial. Parts of it were cooperative. Also, one of the things that I talk about in this article that this came from is, you have to break it down between the different players there. So, the lawyers were very cooperative between themselves, but the parties weren't. Or what happens if you have one party who's cooperative and the other one is adversarial? So I guess to me, that case is an illustration of the value of using these more concrete unbundled variables as opposed to these global, confusing, incoherent models that we unfortunately use, from my perspective, unfortunately too much, that I think we know what they mean, but often are confused and confuse each other.
great. There were a couple of questions, and this might be the last moment for our questions, but about how the concepts that you've discussed apply to child protection cases, where it's probably more effective to remain in court, and the litigation often leads to children being separated from family or placed in dangerous settings. And another asked about, application in guardian ad litem procedures. Is there a specific techniques or recommendations you would make in those kinds of situations?
Sure. One of the things that I did actually just before I came to Missouri was I directed a child protection mediation program at the University of Arkansas at Little Rock. So I'm familiar with that, and also dealing with the ad litem cases. And just in brief, again, I think the same concepts could be used to apply. And you know, this is an example where litigation and trial is really essential in these cases. Even in cases, for example, where we mediated, the court had to enter an order to convert the agreement that we reached into an order. And anyway, I could go on about using these elements as a way to analyze what the parties' interests are, and then also the kind of interventions that the practitioners might use.
Excellent. We're at the magic 10 o'clock hour. Maria or Chuck, would you like to take the field? We usually stay on a little bit longer. John, if you're available,
I'm happy to.
if you have any additional comments, or anybody would like to raise their hand, we can go a little bit more loosey-goosey at this moment with people jumping in.
There was a long discussion in the chat about emotional EDR.
If I could just interrupt for 1 sec before folks ring off, and John, thank you for agreeing to stay a little later.
Oh, sure.
The next roundtable breakfast will be January something, January 2nd, and it will be
seven.
Sorry, and it will be Alexandra Carter on various aspects about negotiation and how negotiation is navigation. So,
and I also wanted to
happy holidays and New Year to everyone who has been here, and thank you for joining. And if you can stay on, let's all stay on.
And just as a reminder, we will be sending out a link to the recording as well as to the slides. And I just reposted in the chat the special discount code for the book, a great holiday reading.
Absolutely.
Great.
So
thank you so much, John. We truly appreciated your joining us this morning for a very stimulating breakfast. And so for those who are on the call, the breakfast is officially over, but we usually hang around informally. So you're welcome to stay for a bit longer.
And I'm happy to stay as long
John,
as people want to have questions.
I didn't want to, I wanted to give as much time for the other participants as possible, but in the post here, I'm wondering, you asked us to take a step away from the techniques and talk about the concepts. If I could call both of those the what, can I take a step away from both of those and ask about the how?
Sure.
These are great ideas, and it's wonderful that someone with your background and skill is able to collect all these. How do we use them? When we're on the fly and in the middle of a flexible dispute resolution process, is it that we have index cards that say, oops, that didn't work, let me pull out card 14? How do we internalize and embed this kind of thinking so it comes up naturally for us?
That's a great question, and I really appreciate it, Chuck. And really what the idea is to sort of have the Goldilocks between these very basic, simple models, the facilitative and evaluative, and the laundry list of 49 plus specific techniques. And so if you have a smaller number of concepts that you can then say, okay, well, what's the problem here? Well, the problem is I don't understand what the goal is, or they don't understand what the goal is. The problem is their assumption is that it's a zero-sum situation, or the problem is that they are wanting to use one person wants to use a counteroffer process, and another one wants to use an interest in options. So basically, what the how is that these give you techniques, or things to ask about. For example, in terms of goals, which is a critical one, you can, lots of things. Again, I'm sure that people on this call do all sorts of things, but like asking, what's most important to you? Asking, why haven't you been able to reach an agreement so far? So thinking about these different concepts can then prompt you to use a variety of different interventions. Again, in the Lyra book, we have a number of appendices that include a long list of questions that mediators and lawyers can ask parties to help elicit these kinds of things, particularly their intangible interests, which is something that, as I say, often people ignore or leave to the end or don't value properly. So let me stop there and see if you want to follow up or if that addresses.
Well, thank you for that, but I'm now remembering that Julie was offering for Deborah Hamilton to talk about EDR. Is Deborah still on? I apologize for.
No, that's fine.
Deborah, are you still on? You may be
You're
muted.
muted, Deborah.
I was muted. Sorry. Yes, it's really interesting about EDR. John, you and I have met on the ABA, I believe, or New York State EDR group. It is interesting that if we can get these people before they ramp up, it would be so much more effective to use our skills. So I was really glad you spoke about that this morning. I'm already in the afternoon. So it really, my question would be, how do we facilitate these skills and get out there to the people who need us so they know we're there? I think that's the biggest obstacle to all of us. We come on the stage when people are already in dispute. How do we educate people who need us to call us early? That would be my question, John. Thanks.
Sure. And thank you for the question, Deborah. And you know, in some ways, this gets to why I have focused really on lawyers much more than mediators. So, you know, for the last 15 years, I really haven't been particularly focusing on mediators, much more on lawyers, because at least in the legal context where I've been dealing mostly, parties don't get to mediators until they've been to lawyers for a long time. And lawyers are the ones who really frame the process for mediation. So they're critical gatekeepers. And so a lot of the work that I did some time ago was working with lawyers and educating them. Now, the good news and bad news about working with lawyers is that they often have become real fans of mediation because it serves some of their interests. The bad news is that they become fans of mediation because it serves some of their interests. So they may want to get rid of cases that are too difficult or uncertain, or a very common pattern that I've heard about is where lawyers find that they're having, you know, what they perceive as unreasonable clients, and they want the mediators to be the bad guy or the bad girl, as the case may be, and tell the client that they don't have a case and that they should settle, but that the lawyers themselves are wary about doing because they're afraid of losing the client's confidence. So part of it, I think, you know, for me, is working with lawyers. It's a challenge. I mean, lawyers and lawyers have a variety of different attitudes about this. And in some ways, what I guess part of what the impetus for this Lyra book is about is to have lawyers think more about these intangible interests and incorporate that into their work with the clients, both, you know, just in terms of the client counseling part, as well as they're dealing with negotiation or mediation. I mean, it's really requiring a shift in mindset for lawyers. Julie McFarland did a wonderful study back in the early 2000s. It's called A Tale of Two Cities, and she was talking about lawyers in Canada, and the two cities were Toronto and Ottawa. And based on her research, she developed this typology of 5 different types of attitudes that lawyers had about mediation. Some were true believers on one extreme, and then there were others who, can't remember the term she used, but people who were very skeptical. And then there are a variety of mindsets in between. Some were very pragmatic about it. I mean, in some ways, part of the issue that you're getting at, Deborah, is, you know, from the mediator's perspective, you know, how do you get them to deal with this early on before mediators are engaged? And so by definition, mediators aren't engaged. I mean, to some extent, that's a question of changing legal culture, changing the attitude that judges have. I know, for example, in my area, in the Western District of Missouri, they have an early mediation program, and that forces people to mediate early on. And so, you know, one of the things is that judges have a tremendous cultural influence on lawyers. And so you know, getting the judges to do this can be helpful. Of course, you know, judges have their own cultural assumptions, often very much oriented to settlement and disposing of cases, as opposed to not necessarily thinking about the party's interests. Although that said, there are many very enlightened judges who I think would be very sympathetic. So let me stop there and see, does that make sense? Or if you have other thoughts or concerns?
No, it makes sense. And actually, because of what my focus is in mediation, I talk to the people who are the end users and often. So for divorce mediators, speaking to groups who are either in the middle of divorce or contemplating divorce, to educate them often helps at least make the people who need us aware of us. I think we are a very litigious society that tends to go straight to litigation because that's all they know. And in my area of practice, absolutely. However, if we can get to the people who need us, as well as the attorneys who might, I mean, now I'm getting attorneys to refer to me, but not before. They wanted to hold on to that. But now I'm getting it because they recognize that these people can work it out. I think that's the mindset you were talking about, shifting that for the judges and the lawyers. But for the group, I would suggest if you have a purchaser or, you know, a client that needs you, you might talk to their groups so that they know you're there. It really does make a big difference.
Sure. And it sounds like you're doing family or divorce mediation. Is that right?
No, I do. Everyone's laughing. I do only conflicts between people over animals, which of course you would think that's a pretty narrow niche, but it happens in divorce, landlord tenant, breeder owner handler, contract, civil. So it's all over the place, vet malpractice. But if I can get them early before the litigators get them, we can usually work it out.
Yeah, I mean, there's some kinds of disputes where people will deal with it, you know, won't necessarily assume that they're going to go to lawyers. Others, you just always are going to go, or normally you're going to go to lawyers. In situations like yours, there may be some where they wouldn't assume that they necessarily need lawyers. And so going to those groups may be helpful. You know, when I was in my private practice in the 80s, I did a variety of cases, but a lot of them were divorce. And so for people who are doing divorce mediation, going to therapists or going to, hairdressers or going to bartenders or people who are the ones who are going to be the referral sources. I'm joking about the bartenders and the hairdressers, although actually the hairdressers themselves might be very good sources of referral. So part of it is thinking about who the referral sources are. In business disputes, it might be accountants or bankers who would be the ones. Although, again, once you get into some of these more where there's a lot more money at stake and where there may be a lot more technical legal issues, people may be less willing to do it on their own and want to go to a lawyer first, in which case you need the lawyer to be on board.
If I could just jump in for 1 second, and Michael Henry wanted to speak about something with a very interesting question, but
Sure.
Before, I just wanted to throw in for people outside New York State court system has gone to a presumptive ADR program, which is overwhelmingly mediation. And one of the concepts of it is to make it as early as possible in the process. Of course, by the time they're in court, they're already, the issues are well drawn, but earliness is important in that. Michael, are you still on?
Chuck, before Michael jumps in, Leslie
sorry.
Thomas from New Jersey has just been waiting patiently with
Oh,
her little
sorry.
blue hand up, and I'm afraid it's going to be lack of circulation soon. So let's give the mic to
handles are in
Leslie
blue.
first, and then next, Mike.
Sorry.
Oh, I lost him. Hi, I've been a lawyer for 37 years and started out as an assistant DA in the Bronx, and did that for 8 years. And I've been doing private practice, highly contested divorces, difficult parties, difficult judges. That's my specialty. And it's not just money. And I've been doing that for 29 years. But my trajectory had always been to really kind of discard whatever the normal litigation tract is and immediately request a four-way before you even exchange anything. Because I find, especially in New York, that there's a power dynamic, and it's not just money. It's a hired gun. It's I need to get control. I need to dominate. And, you know, during the course of my practicing, I find that it's usually the lawyers that are the problem. And lawyers, it's not that they don't want to solve the problem. If you're going to do a contested custody battle and argue over assets, then you're going to start with $15,000 to $30,000. And if you give a lawyer $15,000 to $30,000, he's not going to give you back money. You know, he has to now justify the outlay of the expense. But we all know, even as mediators, and I've just started taking mediation training because I've been a hired gun for so long. It was suggested to me because one day I settled 6 divorces in the hallway outside of the chief administrative judge's courtroom in 1 week. And he was just like shocked. And he said, well, I don't know how you could have done it. These were highly contested, drawn out divorces. And I said, well, I told them how much time it would take for us to do pretrial, trial, post-trial, appellate division. Then I told them how much money I needed for that. And then I explained to them from a normal parent and citizen view and said, well, if you want to send my kids to college 5 times with the money you're going to spend on this litigation, instead of just having a conversation, then that's what's going to happen. They're not even of college age. And see, most people, like John said, they have no goals. They've never set any goals. They don't know what their needs are. So if you don't know what your needs are, you can't set your goals. And they're so used to either the other person taking care of them, the other person doing everything, and now that's going to be removed. So that they're now wedded to the fight. So my thing was, it is difficult as an attorney to take off the hats. But because I do federal and state criminal defense and I represent people who commit murders, I mean, matrimonial and family court is like a ground ball. It's like, it's relaxing. You know, I mean, people will tell you, oh, you know, custody battle and he's late with the kids. And I said, but when you were together, you were complaining about the fact that you don't have time to go to the hairdresser or you don't get to see your girlfriends and your family. I said, you should give your father or your brother the opposite reaction. You know, you should say, you can have your kids all the time. I'm going to Bermuda for 2 weeks. And then when you come back, see how that works. But see, people don't look at it. If you're in an urban place like we are in the tri-state area, as soon as you give any individual a large amount of money, they want to spend it. They feel that they have to justify spending it because you're giving it to them. So the hardest thing that I find as an attorney is how do you facilitate them making decisions that they don't want to make without taking a side? Because all sides, including judges, are forcing you trying to force you as the lawyer representing someone to take a side or to come over to their side or their perspective. And
John, is there anything in that you want to respond to?
Yeah, there's a lot, and obviously you've had a lot of experience, Leslie. I mean, in some ways, what I got from what you were saying was the challenge of analyzing cases where there's a lot of conflict in the question, and this is where I think the framework in our litigation interest and risk assessment can be helpful. So thinking about, you were talking about what the expenses are, the legal expenses, and having a conversation with clients for lawyers early on. Now, these can be a difficult conversation to have because one, it's very hard to predict how much it's going to be, and you don't want to predict too much or too little. And thinking about what the client's costs, what their intangible interests are. And then, as I was discussing with Nick, thinking about what the other side's interests are. It sounds like, you said you're dealing with high conflict cases, and obviously by definition, these are difficult cases, and they may not mediate well or at all, and they may need to go to court because people just have difficult, unreasonable expectations. Having working through with one's own client about what their expectations are, and again, we have an index and an appendix in the book that lists a whole bunch of questions about eliciting this from your client about what their expectations are, essentially to have a mutual education process between the lawyer and the client, to have the lawyer help the client think it through, and then also use these same kind of tools in working with the other side. And that may help in some cases and not in others. I've referred to the book a lot, and I noticed flashing through a number of chat comments that the discount code apparently doesn't work. And so after the call, I will follow up with the folks at the ABA to make sure that I have the right code, or maybe it had been turned off, and I will get that to the ACR folks, and we will get that to you so that it will be available. So let me stop there, and I'm happy to go as long as people have questions, or as long as the hosts are willing to tolerate this.
I think next up is Michael Henry. And just for everybody's information, I went and tried with the code, and it actually did work. It didn't work the first time, but it worked probably the third time. So I think the website's a little wonky, but it will work if you are patient and persistent. So
a good word for the website, unfortunately.
it's testing it to see if you're a mediator to get access to the book. Mike, do you want to ask your question?
Yeah, hi, thanks. Thanks for a really interesting, informative discussion. I primarily do divorce and separation mediation, and occasionally I will run into a situation where one party in the mediation comes in with sort of a fairly deeply held, probably unexamined assumption that the way forward in a negotiation is to present a proposal, get a counter proposal. Often this will show up by the party will send an email with some Google document with all his demands or proposals, or it's not necessarily done in an aggressive demand language. And my approach generally is to try to draw out people's concerns and needs and interests. But I'm also, but I'm flexible, and I believe that self-determination to some extent includes to process choices in my work with them. And I also don't want to completely alienate someone. So, sometimes my gut reaction is to say, no, we don't do it that way. It's not going to be helpful to do proposals. That'll just make the other person defensive. Let's have a little more, let's have a discussion about interests. And to some extent, I feel that that can be felt as the person who wants to proceed with proposals and counter proposals as really not being heard or fully welcomed into the process. So curious on your take on how to proceed with something like that.
Sure. Well, I don't know if you go by Michael or Mike, but thank you for
Michael's better.
Okay. Thank you for the question. And, you know, here's where, again, one of the concepts that I've presented can be useful, which is making decisions about the process. So if it seems that your client or the other side is using a process that
just to clarify, this is me in my role as a mediator, usually without attorneys.
Okay, okay, that's helpful. To have a discussion about, well, what would be the most useful process for moving forward together. And so, and I'm sure lots of mediators do this, which is to say, you know, is exchanging offers and counteroffers a useful way of doing it? Would it be better to talk about what our interests are? Would it be useful to talk about, you know, find out what kind of the typical arrangements are? So to have a discussion about the procedure may be a helpful way to handle something like that. I mean, is that addressing?
Yeah, I mean, that addresses how I would like to proceed, and I often do talk a lot about the how and the process. I guess the concern is that sometimes the party who's coming forward with a proposal, counter proposal approach doesn't really have the conception or the imagination that there are other ways. And they really have some very firm, but maybe unexamined belief that how could anything else work? This is how you do it. I don't, you know, he doesn't know what I'm talking about with this woo-woo process talk. And so how to open up the possibilities for him or her without, although in my experience, it's usually been a him, without, while feel like he is still a meaningful participant in process choices, when he just doesn't have the experience that I do about what processes might work.
Sure, there's a concept of normalizing things to say, well, you know, a lot of people do it this way. I'm not talking about you necessarily, but, you know, a lot of people use this counteroffer process, and sometimes it works well and sometimes it doesn't. There are some other things that people sometimes use. Sometimes they identify jointly or individually what the interests are and what different options are. Sometimes they look for common normal practices. There are a variety of different things. How's this working for you? You can be Dr. Phil. Is this working well for you? Presumably you're talking about cases where they're struggling, where things aren't working so well. And so you can perhaps get them to notice that what the approach that they're using isn't working well, and essentially educating them about what some other options, some other procedural options might be. So again, there's no perfect solution, but that, I don't know whether that's something you've tried.
That's actually very helpful because I think it treads a nice ground between sort of educating them about possible other options while avoiding the pitfall of hey, I'm the expert, we shouldn't do it your way, we should do it my way, which I think can be alienating. But like you say, to normalize and then maybe do a little education about what else is out there. I think that's a helpful approach. Let me ask just a quick other question. You had mentioned near the beginning of your talk that litigation is sometimes necessary for a series of reasons. Where is that in one of your books or appendices?
Yeah, actually, it's in the, I think the very first paragraph of the litigation interest and risk assessment book is a detailed description of you know, lots of reasons why litigation is important. Also, I have a couple of articles going back to the vanishing trial where I wrote about and described why what some values are. I think about it in the current context of, the election, and, we have a lot of litigation over what did or didn't happen. And I think that it's very useful to have the courts there as a mechanism for collecting evidence and adjudicating facts where people have very different points of view. So to me, that's one illustration of it. I mean, another one that's particularly relevant for us is that in the absence of a court system that will adjudicate and enforce decisions, a lot of people wouldn't reach agreements. They wouldn't negotiate because they would just drag things out. And it's only the fear and the threat of litigation in court and all the risks that are involved that prompt some people to negotiate and mediate and to reach agreements. So, I mean, there are a lot of them, but the short answer to the question is it's in the introduction to the Lyra book, as well as some of the articles on vanishing trial. And if you want to see those articles where you don't have to buy the book, although I recommend it highly, great gift for Christmas or other holidays, email me and I'll point that to you.
Okay, if I could
thank you so much.
Skip in for a second here. It's Chuck Newman, and I have to run. Maria, to the extent someone can stay on as host and continue the conversation, I myself have to run. John, I just wanted to thank you for a wonderful job this morning, and how interesting it is to have had all the conversations and emails with you about this and setting it up. It's really great. It's great to know you. And I want to wish everybody happy holidays and happy New Year and all that stuff. Hope to see everybody on the 2nd of January.
The
7th of January. 7th of January. Gotta go, everybody. Thank you so much.
Take care, Chuck.
Chuck.
Thank you. And I'm going to have to kind of go into stealth mode that I can kind of stay online and manage a little bit, but I wanted to just let everybody know, if you haven't noticed, Professor Lande is very prolific, and I've been posting links to a bunch of his articles and resources. They're also in the slides that we'll be forwarding, and just once you get to his website, there's a wealth of information. The next person who wanted to speak was Richard Lutringer. If you would like to unmute yourself and go.
Hi, Richard.
Thank you very much, John. By the way, I've read your stuff for years. Always provocative and great writing. Thank you. And in fact, here's the book that you're now selling. It's a wonderful book too. My question was conceptually as to format, as to which, not format, but as to what concept to use. My field of focus right now is family business mediation. And many of the disputes which I am called upon to deal with are not really disputes that are going to go to court, because no one would want that. But it is almost classical mediation, because lawyers aren't present either. And I find this is actually the source for me of great satisfaction as a mediator, because I can use tools which lawyers, when I do commercial mediation, hardly let me get a word out because they know what to do, So I think part of our problem as mediators is we kind of lump together mediation and try to use all of our concepts in different situations. And if it's a foreclosure, for instance, I don't think more mediation is going to help very much. But in anything dealing with relationships, all of our tools are useful. So I just wanted to point that out, that I think it's the first question is really, what is the BATNA, let's say, or what are the parties going to do afterwards? And if it's a relationship that you're trying to maintain, you really do have to go deep background into what causes it, what's underneath it. And it could be Thanksgiving dinner 3 years ago that caused it, Anyway, so
well,
thank you.
Yeah, Richard, let me just say, I guess I would frame that more as what they're their interests are rather than the BATNA, or the value of the BATNA. I think it has to do, the way I think of it anyway, is what they're really concerned about. And particularly in the legal context, I think that people are often too focused on what they think would happen if they went to trial, which of course is kind of crazy in the United States with a low trial rate, where it's very unlikely that most people are actually going to go to trial. But the lawyers and often the mediators are arguing about, well, if we went to trial, we'd be getting X number of dollars. No, it would be Y number of dollars. And sort of that thinking about what would happen if they didn't reach an agreement. What you're talking about, or at least what I understand what you're talking about, is what they really care about, why they're really having this dispute. And so this question about what's going on for them and what they care about, to me, is really important, and as I say, overlooked, which is not to say that thinking about what the alternative would be if they couldn't reach an agreement isn't important. That's an important part of thinking about it holistically and coming up with a bottom line. Does that make sense, or am I missing something?
No, I think that's a good point. When I use BATNA because we all know what that means, but
We think we know what it means.
in this case, BATNA is not going to court. BATNA is that the majority shareholder brother continues doing it just the way he always did it, and creates problems in the family. That's the BATNA there, that if you don't do anything, you're going to just have more of the same, and maybe not talk to each other for 20 years.
That is, you're right, that is the BATNA, or the alternative to negotiated agreement. I don't know whether it would be the best alternative, but that would be the alternative to a negotiated agreement, which is a factor that people really need to think about, in addition to what the tangible costs of continuing the conflict are and the intangible costs of continuing the conflict, and trying to think about it from the other party's perspective, which people often don't think about or don't understand accurately.
Yeah, good. Thank you.
Thank you, Richard.
So I think we've reached the end of the questions in the chat. John, you can see it's about 10:37, and we are still pretty strong here at 35 participants at this late hour. Thank you so much for a really energetic, stimulating morning for all of us here. And thank you everyone for being with us. Happy holidays, and see everyone next year.
And thank you very much for this opportunity.
Thank you.
Bye-bye.
Bye-bye.